Are seeking leave to file appeal without
When the order was
passed
passed,
on 8th,
certified copy applied,
applied 10th. Has not been.
annex it and then.
Yes, I have annexed. এই যে এটা
দিয়েছেন বলছি এতে লাগিয়ে দিয়েছে
লাগিয়ে দিচ্ছি সার্টিফাইড কপির কাউন্টার পার্টটা ফার্স্টেতে দেখুন
বুঝলেন আমাদের কত 200
যেটা ধরবে সেটা অর্ডার
নেই
যখন আমি করতে গেলাম তাহলে এভিডেভিট এখন
না না এটা 2015 পর্যন্ত হয়ে গেছে এফআইআর এফএমএটি 2015 তো হবে না
পরে যদি আমাদের এখানে
আমার হবে না
আর আগে যদি এভিডেভিট সেকশন 5 আনা হয় তাহলে
আমাদের কাছে 15 আগে অর্ডার 41 আসবে না শুধু অ্যাপ্লিকেশন
up to 2015.
My lord, in item 1,
Item number 1.
we are withdrawing the matter, my lord.
You've got the letter. You are the advocate in record.
Yes, my lord.
You take a responsibility. No, advocate in record is Smita Mukherjee.
My lord, after that, again,
Wakalatnama is given.
yes, my lord. My lord, right now I don't have the letter physically. Otherwise, kindly keeps it. After some time, I can provide the letter, man.
Course of the day.
During the course of the day, my lord.
No, we are recording your submission. You are the advocate in record.
Grateful, my lord. Grateful.
The advocate in record of the appellant submits that the appellant does not intend to proceed with the
Yes, group 2.
oh, WPST.
WPST.
So there are two ways. If one of the judges is available, then we'll have to go there.
No, but Justice Sawant.
If there is a regular determination, we can take up. But we don't have a regular determination.
But Justice Samanto was there in the bench.
But he's not available now.
Yeah, now. No, only
Then a
bench,
bench has to be constituted.
along with your
Or group two, then it can be, but it is a WPST.
ST, W.
This 323B
No, but,
or 323A.
AIR 99 Calcutta, page 29, full bench decisions, if one of the judge is available, then a bench has to be constituted along with the other bench.
Correct. So that is what is a constitution is required. Either the Chief Justice may send it to this bench,
Yeah.
no difficulty, but one has to constitute a bench.
Normally, it will be,
The instant review application arises from an order passed by the division bench comprising of out of time. Section 5. পূর্ব। Who is the advocate of record? Satyaranjan Kundu. কি করবো এটা কার অর্ডার আমাদেরই অর্ডার এটা অ্যাডমিশন আমরা করলাম না None appears in support of an application for condonation of delay. কি করবো কন্ডোনেশন হ্যাঁ বুঝলাম বুঝে গেছি কি করবো ডিসকাস করবো সবাইকে করছি যখন অপোজিশন তো ছিল Yes, same order. Condonation application dismissed, consequently review dismissed. Next.
Contempt matter, item number 223.
My lord, item number 223, I am for the container number 1 and 2, my lord. My lord, alleged container, my lord, I have filed my affidavit, my lord. The reply has not been filed by the petitioner, my lord. And my lord, the applications I have filed, my lord, for,
Is appearing or not?
no, my lord, Mr. Dilip Kumar Maiti is for the petitioner.
This is again Justice Samanto's order. Bench has to be constituted, and this is relating to
My lord, your lordships, my lord,
whatever.
my lord,
relating to what?
direction was passed to conclude a disciplinary proceeding within 31st January 2022. My lord, this
I
could
do
not be.
know.
Yes, my lord.
We did not notice that. At that point of time, we must have a determination. This is relating to group 2.
Group 2, my lord. Initially, your lordship was pleased to release the matter because at that point of time, your lordship was not having the regular determination. Thereafter, my lord, since your lordship was, my lord, taking up group 2 matters, this matter was mentioned, and
Is there any determination given
My
to
lord,
any judge?
my lord, possibly, my lord, before the my lord, courtroom number 26, it has been written that where both the judges are not available.
That is true.
My lord, only one, my lord, lordship may kindly adjourn the matter today, my lord, because that Mr. Bordhon is appearing for container number 3. My lord,
There's been a bereavement.
has been a bereavement in his family, my lord. Lordship may kindly adjourn for this week.
Not today. Next.
224.
Look, I'm for the appellant petitioner. And in bill numbers
Hello.
224 and 225, like, these two are similar matters. These matters pertains to the resignation of 2 doctors. Now, lordships, while your lordships were pleased to pass the order stating that although they have not completed the 5 years of services, it was clearly taken into account that they will have to consider it by not going into that part. Now, my lord, in one matter, being serial number 224, they have filed their opposition, but in serial number 225, we are yet to receive any opposition. Now, my lord, the matter
They
is
chose not to file.
No, our settlement to 25 I find. I mean,
fine.
What was the parent order?
Yes, my lord.
well, can you see the order?
It starts from page 16.
Page
16.
16.
Now, at that time when we dispose of the matter, it was 5 years has already completed.
Yes, yes. Now,
That's why on that score we set aside the order. Press
Yes.
consideration.
Yeah.
yes, my
The
lord.
fresh consideration have been made.
Now,
What
the
what
fresh
fresh
consideration.
consideration?
Now, lord, the fresh consideration has been made by again taking into account that he has not completed the 5 years of service.
Same. Let us see. When
Yes,
we have said that it should not be taken into account, then why? Where is that opposition?
Look, can you see?
Where is the decision? What is this? The Supreme Court judgment? 1 page is given? Oh,
Yes,
this
one
is-
of the matter is pending for waiting. This is a similar issue.
Lord, it is one case of Mukutmoni
Mukut Moni
Odhikari.
Odhikari.
Now, my lord, here he had not completed the 5 years of services. Now, my lord, there has been no order of stay and something was there. Now, even
No, this relates to the same.
no,
Mukut Moni
not the
Odhikari.
same matter,
principle.
not same
Same.
matter.
Is a Mukutmoni Adhikari.
Mukutmoni
Mukut Moni
Odhikari.
Odhikari.
Yes. That was decided by whom?
Lord, that was decided by my lord Justice Shoumen Shen, sitting with my lord Justice.
Uday Kumar.
No, no, Justice,
Who mentioned order?
no, possibly initial interim order by Justice I.P. Mukherjee, then Justice Sen, sitting with another judge. And
It was
then
finally
against
decided.
which, state government special SLD petition it has been admitted, notice has been issued, not waiting for a decision. এতক্ষণ আসছেন?
Lordships may kindly takes up their paragraph 4 of their opposition, where they have again reiterated the same point.
Whether this amendment was brought at the time of argument? Oh,
Yes,
Kindly see the
Mukut Mani
amendment
was there.
page 11, page 11.
Yes, Mukut Mani was considered.
yes, my lord. It was
And-
taken into account at page 18. At page 18, my lord.
18.
Kindly sees the last paragraph.
Yes, notification of 26th
Yes.
of August was taken into consideration.
Consideration. And after taking that, your lordships was pleased to pass the order.
Yes.
No, but pursuant to mandate page 21, the petitioner number is directed to takes consideration of registry letter, taking the same to be
Correct.
filed as on
We are,
date.
we are not satisfied with your explanation. We are holding you guilty of contempt and the
Mr. Nayak was there, Mr. Nayak had been.
Initially, your lordships, we had brought this to your lordship's kind notice.
Let the rule be issued upon them, let us see. New incumbent, put it up.
Yes, new
No,
income.
no, new incumbent has not been added.
না, add করেছিলাম lastly গিয়েছি।
No, no, he has also, he is no more in service.
Well, and in serial number 225 is also of the similar nature. Only the facts are little bit different. And today, my lord, I have just received the affidavit in opposition.
File your
The same order may kindly be passed also.
File your reply.
Reply to that.
Let the affidavit in opposition filed by the LS contemptor be taken on record. The reply to the opposition be filed can be filed within a week from date. By Thursday, next Thursday, put it on. Let the matter be listed on next Friday.
Next week.
24th.
Thursday is a holiday, you just write it.
Nah,
Give it a copy to him.
My lord. My lord.
24th,
24 তারিখ
24
ফ্রাইডে 24 তারিখ ফ্রাইডে
24th.
24 তারিখ কিসের
24th আসবে?
Hey,
একদিনের
reply
ছুটি।
be filed by 22nd,
24 কিসের ছুটি
22nd.
matter to be listed on 24.
My lord.
24th,
24th ই থাকবে।
24 ফ্রাইডে স্যার
Friday, একদিনে। 24th
Friday is the date for contempt. Yes.
Friday contempt এর দেওয়ার কথা।
Can it be on 7th?
State certified copy, if applied for, be given within 3 days from
Yes,
this.
get put on.
ছাড়বেন না তো আপনি।
আমি কি বলতো? আমি একটা সামান্য মানুষ।
Grateful, my lord. Much obliged.
এরকম দেখুন আর দুটো কাগজ আছে, জাস্ট দুটো 2 পেজ পরে লেখা আছে সাম পয়েন্টস।
My lord, in this matter, my lord, learned government pleader is appearing on behalf of contemners, my lord. He is currently
Right.
engaged in courtroom number 13, my lord. He is on his legs, my lord. I'm praying for short adjournment.
Last occasion, Lordship recorded the seriousness of this this is mechanical engineering PhD note 3 rule 4.
Lordship, I am appearing for the alleged content number 6 Public Service Commission. I have already filed my affidavit.
My lord, I made submissions to say that Lordships might be surprised of the gross nature of the deliberate and willful contempt. Only 2 page would be necessary. দেখুন এটা আছে না থাকলে হ্যাঁ 2 page.
The affidavits are filed.
Yes, all completed.
Only is awaiting rule.
Yes. And they are perpetuating this wrongdoing. Lordship, kindly take this 2 page.
Yes.
Well, the tribunal's order was on 17 June 19. There were 10 directions, like change of the rule and everything, 10 directions, including note 3 rule 4 not applicable. That's tribunal held. The writ petition was filed, my lord, in presence of everyone, including the PSC and the state, everyone. My lord, 2nd of September, this is the exact quote. Direct the status quo as on date with regard to functioning of the petitioners as well as the private respondents. There shall also be an order staying operation of the direction of the tribunal. There are 10 directions to change of the rule and etc. by the tribunal. All were stayed. Well, on that date, admittedly, there is no dispute that the private respondents were assistant engineer. Lordship, kindly mark, they were not the executive engineer. Now, interim order was time to time, my lord, in presence of my learned friends. They were extended by your lordship till the delivery of judgment. Now, on 1st of February 23, my lord, this was a detailed judgment of 35 page dealing with that why this note 3-4 will be applicable. Lordship delivered the judgment. Tribunal's order was completely set aside. plus private respondent's promotion to, Lordship may kindly mark, the assistant engineer, not the executive, because he was not executive engineer. He was incorrectly made assistant engineer 2011. So I have no grudge on that. Lordship says that that was not disturbed. But interstate seniority between petitioner and private respondent shall be determined strictly in terms of Note 3, Rule 4, diametrically opposite of tribunal. And this is the entire exercise to be done 4 weeks. Thereafter, my lord, now the PSC, well, I would,
Did they challenge that order before the higher forum?
no, they did not. What they did, if I can just say before your lordship look at it, they exactly acted on the basis of the tribunal's order by, may I show 2 pages?
When they acted prior to 1st February 2023 or after 1st February 2023?
They acted post,
Post one.
and that starting of acting started during pendency when there was a stay of the tribunal's order. They sent, may I say this, the PHE sent a document to PSC when there is a stay, lordship is hearing the matter, making private respondent number 1, meaning thereby what the tribunal said. And they do not disclose it to anybody, not even your lordships. They kept it in the drawer. Now, lordship's order is passed. Following Note 3, Rule 4, I come at number 1 from 2010, according to their document. Now, PSC has used their affidavit. They have disclosed very honestly. We received a document where they are showing private respondents at number 1. And that number 1, that can only happen if lordship's order is ignored, tribunal's order is accepted. And fortunately, I would say that I would my lord, appreciate, despite all my learned friend having taken the PSC, the courage enough to say, PSC has said this, there are so many number of documents that come to us, so it is not really possible for us to find out what is the correctness of that. Some part of is right. We go by what is sent to us. But it is the PHE, if I can show 2 documents before your lordships, lordship will be surprised. Kindly straightway take page 110 of the contempt application.
So really the PHE is in contempt.
Yes,
It's not
yes,
the PSC.
yes. It is, to my understanding, PSC, I cannot say because the order was also on every respondent. PSC cannot,
Absolve its
they cannot
responsibility.
say naive, but I'm trying to be very candid that it may not be humanly possible for the PSC to assume that some responsible officers would be, may I use the word, would be fooling PSC, would be making a completely incorrect statement. They, yes,
You are saved by it.
Lordship, I
but I
don't
said
find the
because I
appearance
thought-
of PSC. That time I was not
must-
there,
honestly,
but I believe maybe they have not represented also.
their affidavit is fair because they have disclosed, they have annexed the document which is showing the gross willful deliberate violations.
Now, what do you want to tell us?
Yes. First, kindly 2 pages, my lord, everything would be clear. Kindly take, my lord, PSC's affidavit.
ওখানে আছে না এখানে আছে? Affidavit in opposition by the contender number
6.
6. Yes, I have.
ওই
এখানে
CPN 909
there are 2.
there are 2 identical cases, so
So you
we are going
taking
with
which one?
WPST 106 CPN 909.
This is
Yes, because all along it was on this. Lordship, kindly take page 25, first the document itself.
yes,
Kindly see at serial number 1,
yes.
Sudeep Shaha.
25.
Now, kindly come to page 110 of the contempt applications. Page 110 is their compliance, the gradation list.
Yes.
Kindly look at who is at number 1. It's me and both the petitioners, Ashim Bishas. Kindly see where the Shudip Shah is there, 11.
Yes.
Now, Shudip Shah 11 can come under 1 if Lordship's Note 3 formula is ignored. And precisely they did so. Kindly come to PSC affidavit explanation. Kindly look at page 24. This is so wrong. Page 24.
Previous page.
Yes, yes. The PSCs. Malad, one format has to be given.
Yes.
There, serial number 18. Whether there is pending civil rule in a contempt of law.
No.
No.
And this is dated 8/8/2022.
Yes. We are before your lordships every day appearing. And there is a complete stay of the tribunal's order. Do not follow this. So internally in their drawer, they followed it. They show Shudip number 1. And once lordship set aside the judgment, directed follow note 3, they did 110 and I am at number 1 from 2010. And now, well, even kindly see the explanation of the PSC, lordship will get it clear, that I say that I would appreciate the honesty part of it.
Which one?
Is,
Paragraph?
yes, I'm saying, but paragraph 6, page 6.
Okay.
Lordship may kindly remember 2 dates. September 19, the order of the tribunal was stayed and Lordship judgment was delivered in February 23. Kindly take page 6. On 12th August 22, forwarded a fresh proposal for promotion to the post of executive engineer along with such annexures, such and such. Therein the name of Sri Shudip Shah and Sri Mongol Bagh have been listed again serial number 1 and 2. That's sorry, madam.
Yes, serial number
1 and 2. This means they are just the opposite what Lordship has said. And their explanation that
Later is at page 22, Lordship.
They say onus, kindly take page number 8, last paragraph. While discharging such duty by the Public Service Commission, the onus of submission of final gradation list containing ACR and ACR, etc.
Where do we?
Well, at page 8, last para. Bottom.
While discharging such.
Yes.
duty.
Of the Public Service Commission, the onus of submission of final gradation list containing such and ACR and ACRs of officers lies upon the concerned department, which in the instant case, the Public Health Engineering Department. The office of the answering respondent has no role to play except the fact that the recommendation for promotion is made in, that's a different thing. So at least now there is a realization by the PSC that we should have checked it up. Why I say, my lord, this is so gross in nature. If Lordship's order is to be followed, I come at number 1 and the petition number 2 is number 2. That's page 110. I could have understood that some part the tribunal's order is complied with. No, from the day 1 it was stayed. I could have also understood that they did it so publicly. What they did, after the tribunal's order, when we are in the midst of hearing with a stay, the PHE sent the proposal to PSC, making the private respondent 1 and 2, ignoring this note. And PSC recommended the same. PHE received them, but do not say to anybody. They keep it in their drawer. After Lordship judgment is delivered, they say we have complied with by putting you at number 1 and 2 at page 110. Lordship also directed the interstate seniority. So from 2010, I am number 1 and number 2. And they give him the promotion to executive engineer. I remain as assistant engineer. Still it is continuing. In fact, my lord, there was an occasion in this matter for to adamant writing. The law officer was directed to be present. He was present. Lordship dealt with it to give an indication there is a limit of everything. And regarding the seriousness, there was a recording of my submissions on 30th of August of 24. This is a fit case for issuance of the rule. If I put a single question to myself, what is the gross violations? The gross violation is the alleged contemners have acted the order of the learned tribunal, meaning thereby they have ignored note 3 rule 4. The whole exercise by your lordships of 35-page judgment was this is applicable.
Lord, I'll again seek for adjournment. Lord.
Oh, this card. Where is he?
It is in court number 13, my lord.
This is the, I think that this is a very senior bench.
Lord, it is.
And today this is a contempt application. Okay.
There are 4 times before these matters were taken up. It's not that lordship is not giving.
Lord,
we
we
are
were-
issuing a rule
My
of
lord, kindly, my lord, my lord, the letter, my lord, which was placed before your lordship, my lord, is of 2022. My lord,
one query, which
Hello.
is if you apply note 4
my lord,
and
rule,
Rule
3, note 4,
my lord.
whether they will come in the first and second position.
They are in the first and second position, my lord. My learned senior has already placed page number 110
Right. So they come in a first.
in a cadre
If
of
they come
assistant
in the
engineer.
first and second
How could he,
position,
my lord?
then in that event, why they could not be put up to a executive?
My lord, may I answer this?
There are posts available.
My lord, may I answer?
We also, if they allow us, my lord, we may not pursue with the
My
contempt.
lord, may I answer that query, my lord?
But there cannot be perpetuations of this.
My lord, kindly, my lord, takes up, my lord, our affidavit filed by this point contender number 1, 2, 3, 4, and 7. My lord, we have disclosed the public health engineering rules of recruitment.
Why you sent this letter to the PSC where you have shown the private respondent as number 1 in the
Yes.
predicate?
Till that,
When there was a stay,
What is your answer?
my lord, till that time, my lord, your lordship's
There
order,
was already a stay of the operation of the order
my
of
lord, the
tribunal.
petitioners, my lord, the petitioners were not promoted to assistant engineer post on that day, on 2022. My lord, they were sub-assistant engineers. My lord, the petitioners were promoted to the post of assistant engineers on 15th of June, 16th of June 2023, after your lordship's order. My lord, prior to that, petitioners were sub-assistant engineer. My lord, private respondent number 9 was the assistant engineer. He was promoted in 2011. So, my lord, that was an internal document. His promotion was not given effect to, since the issue of interstate seniority was under challenge. My lord, your lordships, in your lordship's order dated,
The interstate seniority was now has to be revisited.
my lord,
And it appears that they stand on a first and second
my
position.
lord,
And the gentleman whom you have given a promotion comes on 11th.
11th position.
In that event, why don't you then also
My
promote?
lord, I'll answer that, my lord. That the answer lies in the rules, my lord.
Could have said that we can't revert it back. The situation is such.
My lord,
So we are giving all the benefits to them also.
my lord, may I answer that? My lord?
Could have, why you have not?
My lord, we have answered that. My lord, kindly see the rules of public health engineering service. My lord, after becoming assistant engineer, one has to do a qualifying service of 6 years to be eligible to get promoted to the
person
post
who
of
has been
executive engineer.
Illegally,
My lord, your lordships,
then you will count it as a qualifying service and a
lord.
person who was otherwise eligible, entitled under the rules, you will say that he has not completed 6 years.
My lord, your lordships have also, in your lordships order dated 1st of February 2023, has held that that person's private respondent service and seniority will not be affected or
that is for
hampered.
assistant engineer,
Assistant engineer.
not
My
for
lord,
the
so, my lord, if it's, my
Engineer
lord,
will not be
if his promotion and if his promotion to post of assistant engineer will not be hampered,
promoted him to the
2011, my lord,
executive engineer.
in 2023.
23. So
My lord.
23 on what basis?
Yes.
My lord, if
Order was passed when? Our orders 1st February.
After your lordship's order, they did. One question: did they send this correct seniority list
My lord,
before the
we did.
PSC? Answer is no.
we did, my lord,
This is the question.
on 30th
They
March
never sent it.
2023,
How?
He is correct because the PSC has
Yes.
disclosed that this is what we
My lord,
received.
They did not.
Did
my lord,
you-
kindly,
Did you correct it?
we did, my lord.
Into the PSC?
My lord, kindly take up page number 109. Their own document discloses that we have we have
Page
done so.
26 is the recommendation which we have sent to them.
My lord, kindly see page number 109 first, my lord.
Correct. This recommendation is
The
because
basis of
they
my
have
year.
shown
Yes,
at page 25.
Sudeep Shah as
Sudeep Shah
number
as the
one.
senior most,
Yes.
and
Milord-
two in the month of 23.
Milord, in page number 25, Milord, that recommendation was made in 2022 prior to your lordship's order, Milord.
Did
Milord,
you not?
after your lordship's order-
When you send it, there was a stay. There was a stay as on 25/7/2022.
Milord,
Why you send it?
Milord, it was not given effect to, Milord. Milord, he was not promoted.
Then
He was
when
not
you
promoted,
send the revised one,
Milord.
This was not
if
sent.
you shown this, the revised, the gradation list to the
Yes.
PS.
Milord, we have sent it, Milord, on
No,
30th
no.
March 2023. The government of West Bengal, Milord, kindly see take page number 109. Milord, kindly take a page number 109, Milord.
Yes.
Milord, on 30th of March, we have sent it to the PSC department, the revised gradation list as per your lordship's order.
109,
Milord.
yes,
Milord, 110 is the annexure of that letter.
yes, 109 when you send it, how the PSC has given,
Affidavit.
Milord, may
the executive.
Milord, may I
the-
answer
the
that?
Promotion to the
Milord,
serial number.
first,
11.
Milord, may I place your lordship's order, Milord, that relevant portion?
I am asking you, sir,
Milord.
very simple questions.
But I'm answering.
I understand. You say that in 2022, before the order, you prepared it.
Milord.
Immediately after the order passed by the bench, you have sent the revised one. And in the revised one, you have shown them how the PSC issued the promotional order in respect of a serial number 11 candidate.
Milord.
PSC says it was not. You insisted for the old one.
Milord, we did not, Milord.
You did not.
Milord, what happened, Milord? In 2023, even after revised gradation list, all these engineers were there. Milord, the persons in serial number 11, we'll see, Milord, for promotion to a post of executive engineer, which of the assistant engineers is meeting the essential qualifying criteria. Your lordship, Milord, have held that his seniority in the post of assistant engineer will not be affected. So, Milord, it was not declared that his promotion was illegal. Milord, if, Milord, your lordship have held that his seniority will not be affected, Milord, we have to consider his seniority as well. So we have considered, Milord, his qualifying service.
That is a very apt example of that head I win and tail you lose.
Milord, he has the petitioners.
It's the greatest example. Gradation list is really an eyewash of paper. It's a paper one.
Yes.
I have shown you as number one. But the number 11, he qualifies all the conditions.
Milord, the result
because
will be.
I have illegally promoted him 7 years before, 10 years before. So he qualifies those positions and therefore he should be promoted.
Milord, the result would have been, Milord, that post would be vacant till 2029. Because, Milord, these people cannot be promoted to the post of executive engineer by taking notional service till they complete the actual service in the post of assistant engineer, Milord.
We are directing the relegation back in the content. We can do it just to ensure
Milord, kindly,
it's
Milord,
not only the punishment,
Milord,
but also the consequential order so
Milord,
that
kindly allow us, Milord,
That
more day,
which I
Milord.
brought also that
Milord,
yes,
kindly allow us one more day, Milord. We'll try to satisfy your lordship, Milord. We have some arguable points, Milord.
nothing. We are going to issue.
Milord, kindly, Milord,
We are going to issue.
Milord, kindly give us one more day, Milord.
Nothing.
Milord, one more day, Milord. Any day next week, Milord. Milord, because, Milord, your lordship have held that his seniority need not be hampered.
His seniority means his
Assistant
position
engineer.
in the post of assistant.
Yes.
Assistant
Milord.
engineer should not be.
Milord, his position is.
Seniority. Seniority will create a problem.
The seniority, Milord, is intersect in between cadre.
Then the cadre means the person who is number one will be always regarded as a senior.
Yes.
Milord, he is senior. Milord,
So,
in the cadre of Milord, there are two separate cadres. Milord,
Sir, I understand, sir. There were two separate cadre. One was mechanical, another was.
no, Milord,
When there was a-
not mechanical electrical, Milord.
Who?
Milord, not mechanical electrical, Milord. Junior cadre and senior cadre.
When you subsumed two different cadres into one,
Milord, may
that was the case.
Well,
No, Milord, may I? Milord,
spent
that was the
35
case
days.
before your lordship.
I don't want to say
Milord,
anything on that.
This cadre which I am talking about,
Not
Milord, was not
judgment.
before your lordship.
Not
Milord, we have
judgment.
disclosed
We have
it.
dealt with it.
Milord, this cadre which I am talking about, Milord, this was not under before your lordship for consideration, Milord. This is the 1994 recruitment rules, which provides that there is a junior cadre which has one post of assistant engineer, and there is a senior cadre of executive engineer, superintending engineer, and chief engineer.
Sir, it is. You did not argue when the writ petition was.
Milord, I did not, Milord. That is why, Milord.
No.
Milord,
The case was that there were two different
Milord.
cadres. I think one was
Mechanical and electrical.
And electrical.
electrical. Then the government decided by virtue of a governor's order, they
Yes.
wanted to subsume the
Milord.
both the cadre.
Yes.
Now, when you merge both the cadres and treat it as a single cadre,
Yes.
then the question that arose that while merging it, there will be a disruption.
Yes.
The gentleman who is number 1 in the cadre of a mechanical may go to number 20 in the cadre of electrical.
But he did.
Arguments were advanced that the mode of selection of both the different cadres are different.
Milord.
Therefore, one legal parameter, if I correctly remember,
Milord.
Note 3
Your Lordship is absolutely correct, Milord.
cannot bring it.
Yes.
That was the argument. Ultimately, we found that no, the tribunal says why not, why the note should not apply. We say that it should apply.
Yes.
Yes.
And we directed that once the government was conscious that this situation may arise and given a note, that the effect of a note in a statutory document, we have taken into consideration.
Milord, Your Lordship is
Challenge.
Milord,
Now,
we did not.
directed that act in terms of this note.
Milord.
You have to act. That does not mean, we just say that some persons who have already been promoted, their positions should not be disturbed.
No difficult.
Milord.
But the cadre has to be prepared for this.
Milord.
You say that I have prepared a cadre.
That was not sent to
That was-
PSC for
that's
this.
very good on your part. You say page 110,
Yes.
I have already
Yes.
communicated to PSC. Very, very nice. Good gesture on your part. But the way is that you extended
Yes.
something to a gentleman from your left hand and took it away from your right hand. This is what you did. Now to say, maybe this gentleman who comes in the 11th position in the gradation list, but he would be regarded as a person who has qualified for being promoted to the post of an executive engineer. Because I promoted him illegally. Now the question is when you I would say merge both the cadres, and if there is single cadre,
With effect from 2000
Then-
December.
does that qualification be reckoned from the date when the cadre is prepared, or does that qualification would remain when, because there is only one promotional post for both the merged?
Milord. Milord.
If that being the position, you are in contempt.
Milord, may I answer, Milord?
I am not very much accustomed with the service law. but
Milord, may I
what
answer,
I've
Milord?
done,
Milord, kindly, Milord, take a page number 27 of our affidavit, Milord. Milord,
We
there is
can't-
another cadre, Milord. Apart from those two cadres of mechanical and electrical, Milord, there are two cadres post-wise. Assistant engineer constitute only one cadre, Milord. And then, Milord, executive, superintending, and chief constitute a separate cadre, a separate gradation list is there, Milord. Milord, may I place, Milord? Milord, may I place? kindly allow me one more day, my lord. I'll educate myself, my lord. I'll come back and assist your lordship, my lord. on this issue.
What to do? He does not want to
Well,
want an order against, but the
Yes.
position would be same.
There will be serious repercussion, my lord.
well,
Kindly.
at least I would say, Mara, had I been nothing to do with appearing for my clients, had I been his positions, I would have tried at least to impress upon my clients, look, no matter for whom I appear, the order of the court, if not challenged, requires to be complied with. There is a area where we can make an interpretations, but there is a no-fly zone. This falls under that no-fly zone. That's I think that's the very fundamental thing while appearing in contempt, all irrespective of for whom we are appearing. Ultimately, it has to be the dignity, sanctity. Otherwise, we have got no value too.
Mr. Samanto is not here. He knows what the state government did in one matter, similar situation.
And there is a possibility to solve it, resolve it. The kind of ego that I would not do it because there is a some that
Remember, there was one case like this. State government's attitude was very apparent.
this is about attitude, nothing else.
And we'll take
Because there is a
instructions.
note of the finance. Finance wanted to get it done. They said so.
Lord, nothing trumps, my lord, your lordship's order, my lord. We'll take instructions, my lord. If needs to be complied, it needs to be complied to its strictest sense, my lord. Kindly.
So Samanto was moving that contempt and we hold it
I think
Then
some of
to the rule against the contemners.
well, I would be
Not
request.
the same situation, the attitude
Yes.
problems. That's why in the earlier order, I have used the juggleries. No, what in that case, what happened? The state government, there was a forest that was cut in relation to a forest matter. There was a post of a PCCL. The government that sanctioned the apex post of PCCL
Yes.
with a higher scale of it. They were a regular cadre for a 3 posts of PCCL. There was a blue-eyed boy who was just below the PCCL. The government, as you know, at times may apply for ex-cadre post because of the enormous number of work to be discharged.
Yes.
And the sanction is required for ex-cadre, which is for very limited duration. You know the service law better.
Yes. Yes.
Ex-cadre post was created.
Yes.
That gentleman was put in promotion to PCCF ex-cadre.
Yes.
Extension was continued. When the apex post was created, then this gentleman who was there in the ex-cadre post of PCCF, he was promoted.
Hmm.
Then the senior most of PCCF regular cadre
Yes.
came and challenged. We hold absolutely a malafide. Scrap it. That he cannot. Out of this regular cadre,
Yes.
you have to choose. Then the petitioner who was there, he was the senior most amongst the PCC. He was promoted to apex. But the powers which was there of the apex were robbed away and given to that gentleman who was shifted from ex-cadre to a regular post because that fell vacant. Contempt was filed.
My lord, I understand there is a easy way to resolve it if no one attaches to ego. There are, I believe, 2 posts of executive engineer still available. they can easily resolve. I can also persuade, because we are here not to continue the litigations. I can also make a request, okay, be happy, little here and there. But if everything is taken away, ignoring the fundamental things in the judgment delivered by your lordships,
When usual.
Will kindly, my lord, allow us. Lord, one more week, my lord. Only 1 week, my lord.
Because we took up this matter after such a long time.
yes, yes.
It was taken up in September, my lord. Will
Understand, that's why I'm saying after such a long time, but the manner in which the government leader is avoiding this.
There is a recording. If I can,
Lord, he
Planet
was,
government
my lord, he
pleader
was there on
representing
his
the
legs, my
state
lord.
alleged contemner along with other contemners
It's a-
submits that matter is to be looked up and proper instructions required to be taken as serious allegations have been made by the applicants against the alleged contemner.
My
That
lord,
was the order of your
that is
lordship
there, my
on
lord.
30th of August. Seriousness was apprised
Matter
by
is
recording
continuing,
in
my
the
lord.
order.
He is not trying to avoid, my lord, your lordship, my lord. It was
What is apparent?
continuing, my lord, since 11:30.
On the last occasion, the learned AG appears, then the learned GP appears.
Lord, kindly allow them, my lord. One more day, my lord.
Both are
No, my lord.
absent.
We are not trying to evade, my lord. My lord, kindly allow us one more day, my lord.
Well,
Only
I
one day, my lord.
understand.
Next week,
I
my
will
lord,
help
will.
my learned friend. Once there is an issuance of a rule, if he really wants to do to resolve the issue, it would be helpful for
My
him.
lord, kindly, my lord.
Unless
Do
they
not,
are under some pressure, they will not act.
kindly, my lord. Kindly, one more day, my lord. Will come and assist, my lord, your lordship.
Come at 2 p.m. Otherwise, we can't. Can only give you this much.
As your lordship pleases. Grateful, my lord.
Okay. 228, your lordship, appear for the petitioner, your lordship.
I'm appealing for the rest of contemners, my lord. There was a direction for filing affidavit in opposition. My lord.
Lordship, the same has been served upon me. The affidavit has been served upon me, your lordship.
Beautiful.
Lordship.
Would you like to reply?
Lordship, may kindly grants me a moment. Reply to file, please, Nichita. Reply, please. Huh?
Wait, affidavit affirm হয়ে গেছে?
Lordship, with regard to the এই opposition to দিয়েছেন তো?
হ্যাঁ হ্যাঁ
Lordship, I would not like to use a reply to the same. This is already part of the annexure of the contempt petition. Lordship, may I place the first order?
Yes, please.
Lordship, the order was passed,
Yes, please.
which is at page.
Here, let us leave the opposition.
Lordship.
Orbital. Wait.
Where is the parent order?
Lordship, the first order is at page 155, 31st October 2022.
First parent order which you are alleging that contempt is
Lordship, the order of termination.
our order.
Lordship, the first order is 31st of October
And
2022,
there
page.
was a correction, I know.
Lordship, it's page 155.
Then
Lordship, after this order was passed, I've preferred a review. Since your Lordship, it was referring to an earlier order. Lordship, in a similar matter, your Lordship, if your Lordship remembers, in a similar matter, your Lordship has been pleased to pass an order, setting aside the order of termination. Lordship, the order was that the petitioner was working as a bungalow peon. Now he was terminated with the allegations of theft. Now that order of termination has been set aside by your Lordship. That was the order which was passed. Lordship may kindly takes page 155. Starting from page 155, that is the
so
parent
review
order.
was allowed.
Lordship,
Review was allowed.
Lordship, review.
Review was just
Only
correction,
page.
mal, correction.
Only
Well, there is
correction.
there was
It was a earlier order. there was typing error. That was the only
Was
purpose.
allowed.
That was allowed.
Ultimately,
The termination order was set aside and the petitioner was to be reinstated. That was the order passed.
yes.
Lordship, that is why I'm trying to indicate page 155.
After what happened?
Lordship, it's an order of 2022. Your Lordship, the two orders have to be read together. I've immediately communicated. Now they have communicated, which your Lordship may kindly takes page 169. Annexure C4.
So the order suffers from the information and integrity, and accordingly, it was allowed.
It was allowed, your Lordship. Lordship, the terms, your Lordship, allowed or disallowed, your Lordship. The difficulty was that, your Lordship, since it was referred to another altogether separate order of tribunal, your Lordship, WPCT, your Lordship, those were the typing errors. Lordship, it has nothing to do with the Lordship. Thereafter, page 179. Lordship, there was a direction that since the termination order is set aside, thereafter he has to be reinstated. Now, Lordship, what happens is page 179 is the order passed by the railway authorities forming their own opinion. Lordship, as has just been stated by learned senior in the earlier matter, it's a matter of ego. Lordship, may kindly say page 179. In the last portion.
Again, we have said that he had a temporary status, but now after that he acquired a permanent status.
Lordship.
And then he
Lordship, no,
temporary status. That
Lordship, no scope was given to the authorities to review. Lordship, may I kindly read it? In view,
please, tell us that the authorities can really act as a court of appeal. We will be happy.
No, my lord.
No, let him act as a court of appeal over our order, division bench, even above the order of the Supreme Court, everywhere. Act it in your way. We further notice that one of these person, the singularly circumstanced person, have been absorbed and given a permanent status in our parent order.
Lordship. And herein they have reviewed the Lordship's order. In their own sweet will,
And
nothing to do.
that till date you have not taken any steps for removal.
No.
The gentleman is still there.
The other person, my lord.
No?
Well, main, my lord, the reliance was
Please,
placed.
let us issue a rule upon him.
Grateful, my lord.
Let him come and we are not happy with the explanation.
Well, I will seek time to take instructions, my lord, what
Lordship,
steps
it's
to intend to take.
Sir,
Yes, I.
do it in this way, there is a problem. When you have done with one person, then you should do with another person.
Lordship, it's a 2022 order, 2023,
Well,
their own order.
I had
We are in
one thing, my lord,
2025.
reinstatement order was possibly not passed, my lord.
Consequence, what she says is the consequences.
I was trying to find, my lord, the
Consequence is that our order is, the spirit was very clear that once he has done it, you have done, you were taking about 3 years. The order of termination was that he has committed certain theft. Then we say that the probational period, you can terminate it. Once you say it can be terminated only on the 2 counts, then you cannot take it on 3rd count. Secondly, when you put a stigma, then he has a right to be heard before you take a decision.
Grateful, my
With
lord.
immediate effect, it cannot be done. That is the.
Well, in fact, my last time he was again given a show cause before passing this order.
What?
He could have come, my lord,
What?
because
The
my
matter was pending before the Honorable
no,
Court.
after that he was
Lordship
given a show
passes
cause
an order and thereafter
because my
they
lord,
have
the
decided
order when my lord,
2023.
what her
Did you record any evidence? Did you record anything that there was a theft?
No.
no in
All farcical that you just wanted to cover up.
Grateful, my lord. Nothing has been communicated.
If we see the malafide, then what? Then what?
Your Lordship directs the person to be reinstated. He should be working from 2022 October, November. We are in 2025 January. They have used an affidavit. And they have tried to prefer an appeal over your lordship's order.
No, sir. And you have not taken that ground. You have taken a ground, not probation. He was under the probation, temporary status, so cannot, which was discarded by us.
Grateful, my lord. That was the spirit of the order.
You can't improve your case.
As per rules, possibly my lordship's order, his last page will be at the standard respect party, including Union of India, that there is a period provided to acquire a temporary status at the moment. Such status is acquired if would fructify into a right, and therefore it can be safely said as such engagement against
This is what I say, temporary status has fructified because of this
Lordship.
into a right.
right into.
And pursuant to your lordship's order, lordship, there was no scope given to the authority to
Your
decide
lordship
this
had
right.
said, my lord, this is what possibly the probation may accrue right into employee to get status which is of permanent nature.
Correct.
That is why they have while passing the order have, well, it is not actually a case of review, my lord. They have on facts applying this principle. They have possibly, my lord. This is my explanation, not their explanation. This is my possibly, because such status is acquired, it would fructify into a right, and therefore it can be safely said that such engagement against sanctioned post upon completion of the period of may, I am stressing on may accrue right in the employee to get. I am possibly this is why
Then, sir, you cannot pick and choose a portion of the order which suits you.
Yes.
You have to
for the
read the order in its entirety.
well,
to
second part is
Again, I am saying,
a second part is general manager, my lord.
please, you have not read it. Page 156 in the portion of the order. The engagement letter dated 21st December 2010 would reveals that such engagement was made with the approval of the general manager as substituted bungalow attached to the post at a basic pay as indicated herein above. Our attention is drawn to the terms of such engagement, and it would reveal therefrom that the respondent was engaged on probation for a period of 3 years. And such continuance in service is subject to the satisfactory performance in the job and to the verification of her character and attendance. It is further indicated that such service during the probation period is liable to be terminated without any notice if the document or certificate produced by the respondent is found to be false subsequently. There is an embargo created in the engagement letter relating to the claim of transfer to the workshop. What would reveal therefrom that such engagement, though initially on probation for a period of 3 years, but against the permanent sanction post, and the termination without notice, without serving any notice, can only be done in the event the documents and certificates produced are found to be false. The period of probation is subject to the satisfactory performance and verification of a character and attendance. It does not contemplate a situation where the termination can be made with immediate effect without assigning any reason, or to speak of submission of a false document or a certificate. There is no iota piece of paper produced by the petitioner before the tribunal as well as this court, showing that the performance of the respondent was found to be unsatisfactory during the probation period. It is all along the stand of the writ petitioner that since the engagement was purely contractual, therefore during the probation period there is no fetter on the part of the authorities to terminate the engagement without assigning any reason. The terms and conditions are reflected in the engagement letter, and if the eventualities relating to termination has been provided therein, it is not open to the employer to bring any other eventuality not contemplated therein, as the constitution does not permit the feudal system to work in the government employment.
Well, I had
Even if the respondent was under probation period, yet the termination has to be done on contingencies provided therein and cannot be done whimsically and arbitrarily at the behest of the late petitioner. The respondent in his affidavit in opposition filed before the tribunal has disclosed various circulars and also demonstrated one of the incidents where the similar circumstance persons was absorbed and are regularized within a period of 1 year, which has not been denied by the writ petitioner in its reply. It's sought to be contended that the illegality does not permeate for all time to come, but there should be a complete silence whether any steps or action has been taken to remedy such illegality. Be that as it may, it appears that the stand of the respective parties, including the Union of India, there is a period provided to acquire temporary status, and the moment such a status is acquired, it would fructify into a right, and therefore it can safely say that such engagement against the sanctioned post upon completion of the period of promotion may accrue right into the employee to get the status, which is of permanent nature. So one has to understand, termination goes. What happened? Illegal. You can't.
Well, I'm just.
You have to say that this permanent status. Then we have already indicated that these are the two grounds where you can terminate him during the provision period, even without giving notice. One, unsatisfactory service. Two, false documents or the certificate which are produced. Not otherwise. How can you take a third ground again?
Lordship, and thereafter the notices I have served upon the respondent authorities, I have also tried to adequately explain the two orders together, to be read together. Either today the railway authorities will have to say that they do not understand the order, or they do not understand English.
No, sir.
Well,
You can't take a third ground, which you have taken at page 179.
179.
You have taken.
There was no scope given to the authorities to review the orders when it is already
Say that
decided.
He has acquired a temporary status, and you have said it is noted that neither Sri Sahu has attained temporary status nor he had completed the provision. We have said that he has acquired a temporary status, and that temporary status will accrue a right to become a permanent, the employee having a permanent status.
kindly give me some time to take instructions in this.
What is that? That is the problem with the government officials. Sir, don't take me amiss. When it comes to you for drafting the affidavit in opposition, at least there is some responsibility cast upon you.
Well, I have done the responsibility. I have said exactly this. What they have said, my lord.
Saying, this is contrary. I have no answer to it. What I will give an answer? Tell me.
But
even if you do not agree with me and you want it, then the consequences would be there. Then you should not ask for any time. That I have
no, my lord. I have done this. I have done this.
Understand?
I
We banged upon it, wanted to file. I have nothing to say.
I have done this. They are saying that those observations are factually correct. My lord, I am not
Factually incorrect.
factually. So, my lord, I had said you should have
Why
preferred
did
an
you
appeal
challenge this order before the higher forum?
or during review or during the review.
Why you did not?
Lordship, may I be permitted to make one statement? If Lordship, if that is the submission made that they do not understand the purport of the order, that is not their stand
Then
in
they
the
will get
affidavit.
no. My
Just
lord.
1 minute.
I
Just is not.
understand, madam. We have not. He's not saying so.
Lordship,
He understood. He says that I made them to understand. They refuse to understand.
Lordship.
So he's not at fault. What he will do?
Lordship, then the Lordship may kindly issues rule, your Lordship. They very well understand the purport of the order. When they have decided to issue 179, they have taken the orders of the Honorable Court. Lordship,
General
there
Manager.
are 4 contemners. Anil Kumar Mishra, the General Manager. And this order is issued by Deputy
We
Chief.
have not amended. We have not amended the contempt rules framed by us. In a contempt, it is each and every individual who have been categorized as contemptor must file their independent affidavit.
My
Composite affidavit like a writ petition. Because they are to be punished on the basis of this. If the deponent, if somebody comes and says that I never said so, then how can we proceed and punish him? How can we,
I'll ask each of them to file affidavit.
irony of the thing is nowadays, with deepest of respect, nobody looks at the rules, nobody dare to look at the provisions of law. Only thing is they know the fact, come, file it. One judgment from the internet, they found one line, file it.
Your Lordship, this order is passed by the Deputy Chief Personal Officer, page 179. Lordship, the four contemners are at page 5 and 6.
Rule 29. The respondent or the contemner may file an affidavit showing cause and the petitioner may file a reply within such time as may be directed. That means that each contemner, when it is in a singular form, it is being treated as a each contemner to file. It never says so that a composite contempt application.
Right.
It's like a, I would say, maybe it's a quasi criminal, where if there are 5 accused against whom the trial is going on, every accused has a right to defend himself. Here also, he has the right to defend himself.
Right.
How can it be done in this way? This is absolutely against the rules. So I can give you a time on this technical ground
Right.
so that you come with the concrete one. And I do not know what will happen.
Lordship, may I only pray your Lordship, let a very
The
short date be
applicant
given.
Not to be
after 11th.
Why?
My panel will possibly expire, my lord.
Yes, 231.
232, my lord.
Where is Mr. Divas? Nothing. Nobody. Surveys has been affected or not. Nobody knows.
You to leave me in your place service.
Available, right? Not today. It's called 232.
Time for the applicant. In this matter, my lord, the contemptor has been changed. I am seeking liberty with your lordship to add new incumbent as a contemptor, my lord. And will serve to him.
It is submitted by the council appearing for the petitioner that uh, that the alleged contender
Contemptor number two
has contender number two is not holding the post in such capacity, and a new incumbent has joined to such post.
Mr. Khalil Ahmed has joined, my lord.
No, it is only one contender.
Yes.
There is no two contender. Petitioner contender number two is not there.
Yes.
There is only one contender.
Contemptor number two.
No, is a contender. BP Gopalika is the
Yes.
only contender.
Only contemptor, my lord.
So
He has been changed.
Everybody
In
is
his place,
holding the post.
Yes, retired.
The post.
Principal
In such
Secretary,
capacity.
Government Principal Secretary.
The new incumbent has joined to the said post, and therefore the leave will be granted to add the
Particular retired for
new incumbent. Such leave is granted. The petitioner is directed to serve the copy of this contempt application upon the contemners by speed post and shall file the affidavit service on the returnable date. Contempt application is made returnable after 3 weeks. Term of-
Your lordships. Well, all have been given appointment except one who has been rejected. Similar, my last date also I had said his was under consideration.
Then there is something else. The appointment orders, your lordship will see the last order passed by my lords. Because temporary and all those things have been added. That will be resulting in a disastrous prejudice, my lord.
Out of 19 persons, 6 persons have been appointed and they have also joined.
Last time, man.
4 persons, though reported on the basis of the letter of appointment having served, but could not produce the complete set of papers. Those 4 have been appointed.
Yeah.
They produced the letter.
Everybody,
They've been
every
appointed.
joined, well, all have joined. Mother,
6
18 have
10.
joined.
Let us go. 10.
Yes, ma'am.
Other candidates are concerned, they did not report. Delegation means
Mhm.
out of 19, 10 joined, 9 remain.
Right.
Out of 9, 8 has also joined.
8 has joined, ma'am.
Joined.
Last joining is September 24.
And then you say that remaining 3 candidates, out of these 2 candidates have been found unfit, have been recommended for lower category post. They have joined.
Two. Out of 3, 2 have joined.
And then remaining 1 candidate was found to be completely unfit. What was he has not been permitted.
He has not been.
Why unfit?
My lord, as per the rules, possibly, my lord, he does not fall into the category. Their recording is as per the nature of the disease, high volume MHSPC is incurable and progressive. It has chances of recurring and developing into castrate resistant disease in
No,
future.
on that I have nothing to say. But my lord, I have handed over a document.
Now
which-
he has given a reason. A person who is medically incapacitated.
My lord, I am not on that. Lord,
He is
I am not on
some
that.
of
I am
other
on
points,
something else, my lord.
What else?
My lord, they have been given trainee trackman. They have to acquire qualification.
That you can't choose that where you
No,
are.
no, no. But temporary, I have given the document. Your lordship was surprised.
My lord, most interesting
The
thing is
period will not
this
be counted
objection.
for any service.
They had,
Lordship will
my lord,
look
their
into it.
contempt was on the basis of some other people have been given. We have not been given. Those people were also given on the similar same
Let them
language.
show that.
It is
How
your
it
part
can
of
be.
your petition, my lord.
No. Show the letter of appointment. Show us.
I've given your lordship copies. And there, my lord, I have said, period, it says, my lord,
No. Those persons who have been appointed, others.
they were not given that. It's different.
Same language,
Let me
same
say-
language. My lord, I today don't have that file, my lord. The original.
As it is, the matter comes after so many days. We lose track of the matter. And now he says the judge doesn't have.
Now we are picking up everything. Don't worry. Pick up.
No, but contempt, my lord, is difficult to come because other matters are there. Na? Order 41, your lordship has a
Now order 41 gone from Monday.
স্যার আপনার পিটিশন যেটা অরিজিনাল কন্টেম্প পিটিশনের কপি দিন আমি ওখান থেকে দেখিয়ে দিচ্ছি
আরে আপনাকে যদি
my lord I am asking him to give his copy of the petition my lord he
বলে লাভ নেই।
Take it from her.
original copy my lord.
No. Contempt application. না, writ petition টা পুরো এখানে আছে writ petition.
No, it was possibly annexed in one of the contempt applications, my lord. Not the contempt, my lord. This was, my lord, renewed, my lord. Contempt was original. Subsequently, they had made filed some application, my lord.
In a contempt.
Yes.
এই contempt দাও ফাইলে আছে কিছু can.
আমাকে contempt এই দিন একটু আমি দেখি।
My lord, kindly seize this document, my lord, the appointment letter given to them. এটা একটু জজ সাহেবকে
No, no. Somebody who is a similarly circumcised.
Similarly
First, your lordship
circumcised.
will look at this, whether this is conscionable. Just look at this. It is there in your lordship's file also.
Stream.
Wait, wait. Let me turn now.
What is the minimum educational qualification prescribed for the permanent post?
Not there, because all were below
no.
metric, class 8 pass was given appointment.
So,
This was held by your lordship in your lordship's order.
Mhm.
where is the another? Where is the other appointment letter?
The previous on which they had
The
relied.
circumstance person. Where is the appointment letter?
That your lordship has already considered by three
No, very
parts.
sure.
Let me
just,
see.
Just to have a glance of those letters,
Possibly,
the circumstance persons, they have been given a permanent, not like this. Let us see.
possibly. madam. Page 65, এটা বলো। এখানে আমার কাগজ নেই তো, ওগুলো সরিয়ে নিচ্ছ তো। এটা তো এখনকারটা, না না পুরনো দেখো না আমাদের কিছু আছে কিনা, এটা তো এখন যেটা দিয়েছে।
Oh, that is here also saying that this gentleman was class 7-6 pass.
Hmm.
Says that you will be treated as
Page
trainee
65,
if you pass 10th, then you will be treated as regular employee.
otherwise
But
you'll remain
may
temporary.
I tell you that? If the age is there, the qualification could be altered. Now here, they have given appointment at the age of 48, 50.
Look at it. Like your application, you have annexed.
Not my application, probably it is the other set, Lord.
No, no.
Probably it is the other set.
What is the date of that order?
2016.
60. Now 2024.
But then they were given at the age of 32, 34. Here we are appointed at the age of 48, 50, 52, 54, 56. Is it conscionable? First of all, my lord,
And-
from 2012
my
it
lord-
is happening. 2012 appointments were to be given, your lordship
They
remembers?
cannot seek
My
a
lord,
better
Justice Raja
status.
Surya's order.
The case is
My lord,
basis
Justice
on,
Raja Surya had given that order, your lordship remembers, on the basis of which your lordship ultimately proceeded and passed the orders. That qualification will not be a ground, medical PET will not be done, or even if it is done, no one will be failed. All these things.
that was on the basis that similar
Now, how will we
circumstances
get out?
people had been given appointed and they had shown these appointment letters. This standard format, my lord, same order,
But
because
then how will
they cannot be
ultimately,
given
my
a
lord,
better
not even
status
get
than those
pension?
people on whose.
No, there are two aspects, sir. If before Raja Surya, the education qualification will not come. So if we say that your educational qualification is below, I will not grant you a appointment letter, that's one thing.
That's what they did.
No, that's one thing. That says that though you do not have a minimum educational qualification, in terms of the order, I'm giving you an appointment. Now you work. But I say that if you enhance your qualification, that you will get all the permanent.
It would be possible. One is that, my lord, your lordship has held that qualification will not be a bar. Can they invoke that same in a different way? Only lordship will kindly consider this. I am not saying anything else. Your lordship has
I have not seen. Now, but by this time, I have forgot. What I have
naturally, we are forgetting having the brief every day. We are forgetting. But the fact is, my lord, that minimum qualification will not be a bar. They had stopped. Why your lordship had directed them the application to be accepted? The application was that minimum qualification is not there. That was the ground that was shown. Then your lordship said, no, up to Supreme Court, you have lost the matter and now you are giving the same reasoning. You cannot do that. Give them appointment. Now, if the appointment is given, but with that clause, is it?
Can you summarize in a crisp form that what has happened?
Lordship,
And then what they wanted to just by pretending that I am complying the order, but in effect they are acting contrary to the judgment of the courts.
my lord, Lordship will,
If you can demonstrate, we'll
Lordship.
definitely see to it.
my lord, Lordship need not look to that brief. This was the petition we had filed before my lord.
No,
And-
please summarize it. Summarize that this is what the.
My lord, only sees this, my lord, how they had. This was the reasoning given for not giving the appointment.
No, this was set aside. Please. It is not that. I'm telling you, please consider this. Had they refused to give an appointment as you do not have the requisite educational qualification, then they are directly in contempt with the order of the court. What they are saying that I'm giving an appointment, but your status is this. Your status would get changed if you acquire a minimum educational qualification. One thing else. If you can show that this is a farcical approach or an approach pretending the compliance of the order, but in effect in defiance of the order.
That's what I'm.
If you can show it from the excerpts of the observations made in the different orders, Supreme Court, everywhere, if you can show, we are at one with you. We are at one with you. That's why we want a small write-up for that.
I'll do that.
With quotation.
I'll do that, my lord.
With quotation.
I'm grateful, my lord. I've understood what is confirmed, lordship.
And my lord, my case is that when you have
Your case is very clear, sir. No difficulty. You say
that
educational,
on the say this
educational qualification is not a bar. Court has held.
no
I have not created bar. I am giving an appointment. I say,
no, my lord. My case is that you have claimed parity with some people, some petition.
you are gone, sir. If
No.
you say that that was rejected by us,
No. Parity, my lord. Same appointment letter has been given. You are mere saying that.
correct, sir, correct. When you say parity, then second thing is that he's saying that educational qualification cannot be a bar. Let him come and demonstrate that if those have been appointed in a more
Yes, my lord.
different manner.
Yes, my lord. Yes, my lord. Yes.
Give them
But
next week. Next
Wait.
week.
Or, my lord,
Next
2
week.
weeks, my lord. Lordship keeps it 2 weeks. Because,
No,
no, why I'm saying, my lord, I won't be here.
we'll forget.
I'll give you a lordship. Don't worry, my lord. I'll give the shortest possible. Your lordship knows I try to make it as short as my lord.
Then on 31st.
31st.
first, they can give me.
Yes. For the next.
I'm grateful.
My lord, I am appearing for the petitioner. My lord,
order has been complied with. 31st. Order has been complied with. This is an
34.
no, my lord, the order has not been complied with. The opposition, I want to file exception to this affidavit of compliance. And Mr. Chakraborty is yet to file his affidavit of
My lord,
compliance.
may I appear for the Secretary of Finance, my lord. Dr. Manoj Pant is no longer the Secretary, alleged containment number 6 herein. My lord, Mr. Prasad is the new Secretary, my lord.
Let me-
We have affirmed we have not affirmed the affidavit, we have prepared it, and we have no objection that too.
Yes.
kindly see page 6 of my affidavit.
Page.
Page 6 of my affidavit.
Yes.
And page 7.
My lord, we want-
Shotto Das, serial number 5.
what has happened after filing this contempt application? They have reduced the salary of the
No.
petitioner.
No. Whether
And memorandum of 2016 and 19 has given a complete go by. I can demonstrate your lordship by filing the
Whatever,
exception.
just, the respondent number.
6, alleged contempt number 6.
I'm appealing
It
for
is
the,
submitted that
I
the
mean,
alleged
one,
contempt
two,
number
three,
6 is
four,
no
and seven.
longer holding the phone.
My lord, may I have your lordship's leave, my lord, to allow me yield, my lord, in favor of landed government freedom.
What?
My lord, may I have your lordship's leave to yield in favor of landed government freedom, my lord, he'll make submissions.
Your lordship, first, I tender my apology, my lord. I have heard what your lordship has fallen. I apologize, my lord. My lord, I'll take 10 minutes. I'll try and establish the case of the contempt as his defense, my lord. So if your lordship kindly gives me, I'll just make some arguments, my lord. If your lordship, because he has made extensive arguments, that is why I'm beseeching your lordship. Just gives me 10 minutes, my lord, if your lordship.
We can't shut.
No, my lord. I'm just seeking, my lord. I will be just very brief. I'll just point out certain things, my lord, and I will just point out what defense I have taken in the opposition also. And on that basis, if I can extend the defense, my lord, what I extend today, my lord, is that, my lord, if your lordship holds, my lord, that there is a contempt, my lord, there was no willful attempt to act in disobedience of your lordship's orders. That is my first thing. And second is, my lord, I am ready to yield to whatever orders will fall from your lordship. But I will.
Can we?
No, my lord, that is what my lord, I'll just try and establish that, my lord.
Improve the order.
Yes, my lord.
In the contempt.
Yeah, my lord, that is your lordship's domain. Whatever orders your lordships will pass, I will abide by it.
Not done.
My lord, that is what I'm trying to show your lordship, my lord.
What you have not done.
My lord, that is what I'm trying to show your lordship, that whether I've done it, whether I've not done it, and if I have not done it, was it willful? My lord, this will be my gamut of argument. So if your lordship kindly grants me, my lord, may I just start, my lord? My lord. My lord, your lordship will kindly take your lordship's order. I know it has been read out extensively, but my lord, only for my
Page 85.
For me to start, my lord, I need to start somewhere. So your lordship kindly takes page 85
Contempt application.
of the contempt application. My lord, the last paragraph is the main paragraph, my lord. In view of the discussions made here and above, the impugned order of the tribunal cannot be sustained. The same is hereby set aside. Since the private respondents have been promoted to the post of assistant engineer, such promotion shall not be disturbed. My lord, I have stopped here for a moment, my lord. My lord, this is also a direction from your lordships, that if and where a private respondent is an assistant engineer, such promotion shall not be disturbed. My lord, my client would have read it, my lord, that when the promotion is not to be disturbed, the accretions and whatever rights fall from that is also not to be disturbed. Why I'm saying this, I'll come to that later. Then your lordship sees, however, in the event the petitioners are not promoted to such posts, though it is claimed that they are now, the inter se seniority of the petitioner vis-a-vis the private respondent shall be determined strictly in terms of note 3 to rule 4. No, sorry, note 3 to rule 4. Now, my lord, may I now point out two things. First, my lord, that has been done, and obviously on the basis of that, your lordship, well, kindly allows me, my lord. On the basis of that only, the contempt is standing. Because according to that list, my learned friend's client are 1 and 2. Yes, my lord.
Page 109.
Kindly takes page 109, my lord.
Yes, the stand is different.
But PSC can take whatever stand, I'll come to that later. Let us understand what is in the contempt jurisdiction. What has been alleged and what is the basis of the contempt, my lord. My lord, kindly takes page 109. Here, my lord, at page 110, your lordship will find they are placed at 1 and 2. And my lord, the private respondent is placed at 11. My lord has got that. The my lord will also notice, my lord, this is made into one cadre, mechanical, electrical. One cadre.
Order reference.
My lord, the 110, my lord, it is also said that this has been done pursuant to your lordship's order. So, my lord, this is the position. Now, my lord, when this has been done, my lord, on that day, my lord, if your lordship kindly takes this list, And my lord kindly takes the first part of the order where your lordship has said that the promotion will not be disturbed of that person who had already been in the assistant engineer post. Now, my lord, if that is the case, my lord, he was there in 2011. That person became assistant in 2011. Now, my lord, if he has become an assistant engineer from 2011, let us say till 2018, my lord, he has developed some kind of, my lord, experience which is attached to his work as an assistant engineer. Now, my lord, your lordship, in our opposition, my lord, we have specifically stated, my lord, that the promotion to executive engineer is done on the basis of a rule. That rule, my lord, has certain requirements. One of the eligible criteria is, my lord, which is one of the qualifying criteria, is 6 years of experience as an assistant engineer. Now, my lord, I'll take two situations. One, my lord, where, my lord, this list is there, and let us, for the time being, only for the time being, I'm not going to shy away from that. First, for the time being, let us find out, let us say that there has been no recommendation for any executive engineer. I'm just saying this, my lord. On the basis of this list, my lord, petitioners would not be qualified. On the basis of the reading of your lordship's order, what our client felt is that 6 years experience has been fulfilled by the respondent, the private respondent. So there could have been only one person who could have been recommended to the post of executive engineer. One. Next is, my lord, may I just also take this, my lord, the second example, that they are on the same day, my lord, they had been made assistant engineer. Then, my lord, if I take this part of your lordship's order, then I'll be acting in, with humility, I say, my lord, there's a chance that I might be acting in contempt of that part of the order. Because your lordship has said that his promotion is not to be disturbed. So what I'm trying to submit, well, again I say, whatever falls from your lordships, if he need to be relegated, we'll do that. If your lordship directs them to be posted, I will do that. But I did not have the intention of overlapping someone. Now, PSC, Public Service Commission has taken a point now. But first of all, with humility, I say, Mala, that was not a part of the writ petition, but your lordships always have the domain. Not the writ petition, sorry.
Is a contempt when they allege that you have done in violation, then they are also being dropped in. Then they say that why I recommended this. They are within their power.
No, I am not saying that. Malad, again I say.
They have done it on the basis of this.
Yes, Malad, I'm definitely, Malad, what I'm submitting, Malad, this point was not the part of the petition, the contempt petition. This has come up from your lordships now. So, Malad, I could not answer that in opposition.
It was there. It was very much.
What are you talking about?
Yes.
PSC affidavit is.
Malad, kindly see.
Part of the contempt.
My language was you gave me a paper seniority.
Malad, that is not the point which I'm saying. The PSC's point was not in that contempt petition. It has come up in the affidavit of PSC. So I have not been able to deal with it in my affidavit. So what I'm trying to say is.
That's the disclosure that this is what has happened.
Yes.
Your case is that, look, this is the operative portion of the order. The judgment says that the position or the promotion which has been given to the private respondent as assistant engineer should not be disturbed. But the gradation list has to be prepared in accordance with note 3 of rule 4. So, according to you, page 110 and 109 to refer, saying that I have done it. No difficulty that you understand. The PSC has come up with certain documents and they have disclosed that what has happened.
And what has happened, my lord, the only
Your
thing,
document. He has disclosed your document.
yes, he has disclosed that I have
Then
recommended.
It was sent to them. On the basis thereof, everything was done. Shows that the private respondent is still shown as number one position.
My lord, he would be.
How?
My lord, that is what I have been trying to.
Engineer, how could it be?
No, my lord.
What
My lord, again, my lord, your lordship kindly sees.
are you talking about?
Kindly sees, my lord.
That's an affidavit that shows.
Kindly see, takes page 25, my lord, of that affidavit.
Page 25.
Of the PSC affidavit, my lord.
The PSC affidavit is starts from page 22.
My lord.
It says,
Yes, my lord.
it says that the extent rules, recruitment rules provide filling up such post by promotion from the confirmed assistant engineer who has served more than 6 years as assessor. The undersigned is also directed to send herewith a formal proposal for promotion in Annexure A, together with the list of 5 assistant engineers in Annexure 2, along with the checklist in Annexure 3, and the copy of the recruitment such and such. Then the Annexure 1 says, come to serial number 18. Whether there is any pending civil rule, which is of 12th of August 2022, rule of law, and if there is any interim order of the court in the matter of filling up the post proposed to be filled up by promotion, the answer is no. When there was already a subsisting interim order staying the operation of the order of the tribunal.
Or tribunal order ওটা senior ছিল, but just have stay করে দিয়েছে।
That's the intention. So there was already a subsisting order. There is no difficulty. That will also be reflected from paragraph 6 of the AO. Yes. Para 6 of the AO. Why I said 6 of AO?
PSC,
Paragraph 6.
Of PSC.
Page 3, page 8, last paragraph.
No, this is not para 6.
Actually, can you take page number because the para starts from.
No, this is paragraph 10.
Yes, paragraph. Yes. One is page number 6. Para is.
Para 6 is at page 3.
Para 7E is first. Page number 6, my lord, top paragraph. Even the date. Serial number 1 and 2.
Interim order, page 45, contempt.
Yes.
Just leave it.
And the onus part, page number 8, last paragraph. They said it is not our onus while discharging.
Stay করেছিল যেখানে
And they annex exact document which was sent by the PHE for the purpose of granting promotion to the private respondent during subsistence of clear-cut stay of tribunal's order, including no steps to be taken by our court. That is at page number 25 is that list. Page 24, serial number 18.
Yes, that's it. 25.
And 25 is, this is something contrary. 25 is tribunal's order. If tribunal's order is to be followed, then he will come as number 1 and 2. That's why it is so gross what he's saying. How could he do so?
My lord, may I? If your lordship kindly permits me. And let us. My lord, will kindly take the interim order your lordship has passed, my lord.
Yes.
Mr. Dhor,
Yes, yes. Where is the interim order?
Yes.
Page 45, my lord.
Page
45.
46 of the
Of the contempt application.
Starts at page 45, my lord.
It's
Tribunal order to the
yes.
my lord kindly sees. My lord, what the challenge is to the order of the tribunal where, my lord, but order to it is the.
There are two components.
Yes, one is status quo
Status quo as with regard to functioning,
of the petitioners as well as the private respondents.
and they're staying the operation of the direction passed
Directions made by the tribunal where the state has been required to do certain specified acts.
So
Okay.
nothing can be done
Act গুলো আছে
on the basis of that.
I'm saying.
two separate cadre certificate promotion process.
The tribunal directed many things.
10 things.
Yes, my lord. So your lordship had directed, my lord, the directions to be not given effect to. And one is status quo.
Right.
On a status quo, even as on the date of your lordship's order, no,
No.
executive
2011
no, executive.
2023 এর পর
After order of court. So, my lord, status quo as of the post, my lord, kindly appreciates, my lord. On the date of your lordship's order, this person was an assistant engineer, the private respondent.
Nobody disputes that.
So, my lord, I am only trying to show, my lord, the
But
violation.
but there were 10 directions in the tribunal.
My lord, I'll place those directions, my lord.
And there was a stay of the operation with the clarification.
My lord.
That there shall be stay
Of the
effect
directions.
where the state were required to do certain specified act.
My lord, I will,
Those 10 directions.
I will
not
show
to be
that, my lord.
followed.
I will show that, my lord.
Show us the 10 directions.
Yes, my lord.
Show us the 10 directions.
My lord, kindly takes page 43. But one thing, my lord, may I just say, my lord, today, my lord, and again with humility, kindly does not, my lord, these are my submissions. It should not fall upon my client, my lord, but only this is a technical submission which I am trying to make on the point of law. My lord, your lordship will kindly see. Yes. My lord will kindly see that the contempt is only with regard to the order of 1st February, which is before your lordship. But since it's falling from your lordship, my lord, because this I'm taking because under the Contempt of Courts Act, my lord, these are points, my lord, which I can take, but I'm trying to establish my defense also, my lord. But it does not take me amiss, that's my submission, my lord, not on my client, my lord. But there is no contempt of this interim order which your lordship has been shown. But again, I'm taking your lordship to page 43. Kindly comes to page 43, my lord. And I think these are the 10 directions, my lord. I'm sorry, my lord, because I did not, also I don't have my brief.
I have an answer to that, but I'm not saying anything because I wanted you to complete.
No, my lord, whatever is falling from your lordship,
The answer is there, very clear.
But if then I will try and answer that, my lord.
There's no answer from your end. You just complete your answer.
Then, my lord, well, if your lordship has already minded, my lord, then.
Minded. The answer is very clear.
My lord.
An interim order of stay is passed during the pendency of a proceeding.
Definitely, my lord.
Which continue till the final disposal.
Definitely, my lord.
And therefore, once the order which is impugned in this particular the tribunal's order is quashed and set aside by this court,
my lord.
That means that first thing is that the order is not alive in the eye of law. The order remained in suspended animation throughout the currency of the act. And if any act is done on the teeth of those orders which has ultimately been caused and set aside, and despite having been put in suspended animation, this has the effect that there is there is the, I would say the willful, I would say the inclination to flout the order of the court. Does it not mean that?
Well, I'll try to be I'll try and kindly does not, again take me amiss, my lord. But my lord will kindly appreciate if your lordships first.
Giving you a very simple example. As you know, as I am grown, always a civil example. A temporary injunction application is disposed of,
My lord.
by which it says that the defendant or the plaintiff will be permitted to make the construction. The order is challenged by the defendant before the appellate court. The appellate court has stayed the operation of the order, saying that you can't. It remained. Ultimately culminated into a setting aside of that order.
My lord.
Now you say that it appears that there was a violation which was committed.
By construction.
Construction is committed. After this order was set aside, then he comes. It's a technical plea which says that no, I have not made any construction after this order is set aside. This construction must be in violation of the stay order. This technicality will overweigh the conduct of a person, as he has not taken out a separate application for contempt. Article 215 is not only the contempt powers which is conferred, but also court of record.
Yes, my lord.
So the conduct is one of the paramount thing that on a technical ground.
My lord, that I'm again.
That all depends. I say that there are two stages in the contempt.
That is what I said, my lord. I'm answering this.
Like a session trial. It is just like a session trial. One is holding the person guilty of commission of an offense, and the punishment is the quantum of
punishment
or the
punishment. Yes, my lord.
So once it is found, there is a guilt.
My lord,
punishment will vary on the basis of a special fact.
Definitely, my lord. But what I am saying, my lord, that is why, my lord, I wanted to.
As far as the contempt jurisdiction is concerned,
My lord.
The court not only punishes, otherwise simple punishment for up to the period of 6 months will validate the illegal and wrongful action done on the teeth of an order. So a person will be very happy by serving the sentence for 6 months, and
that is why I submitted in the very first moment I submitted.
The court will also see that it is restored to its original position as well.
And that is why I said, well, if your lordship wants to, I said I will only act in terms of your lordship's order.
This is what really
But my lord, may I just say this?
Yes,
My point which I had taken, my lord, with regard to the contempt jurisdiction not having been invoked for that other interim order, my lord, may I? My lord, I am not taking that. I'm not taking that as an only defense, my lord. I'm trying to show your lordship why I'm not in contempt of this also, if that was there. First part I have said, my lord.
Reacted to it when you say technical.
My lord, that is a technical point, my lord. We take all.
That's for we feel the answer to a technical point.
My lord,
now,
my lord, yes, my lord, my lord.
Come to the merit.
Yes, I'm on the merit now, my lord.
Yes.
My lord, first part of your lordship's order.
Commandments, how you can define.
My lord, yes, my lord. First part of your lordship's order. That status quo. My lord, I humbly submit.
That's why we restored. We say don't disturb their position.
No, my lord. I am saying, my lord, of the order of 2nd September, which your lordship, that interim order, there was the first part, which said status quo. But I humbly submit, there was no change of status. First part. Now the second part is, don't do things which have been directed by the.
This is where the PSC has come up and said,
tribunal.
Done thing.
Well, let us.
Well, where it lies.
Yes, my lord, let us see that, my lord, kindly, my lord. My lord. It said note 3 of rule 4 is not applicable. Final gradation list published on such was prepared based on note 3 and as such the same is set aside. No, এটা নয়, এটা তো order নেই, এটা তো judge এর order.
না এটা ট্রাইব্যুনালের
Tribunal. 3, my lord, final gradation list of such and such is set aside. Main prayer of the applicants was to direct the respondents to act on the basis of finally published gradation list dated 29th March 2016. But we set aside the final gradation list as such the OA of 2016 is dismissed. The communication of the Joint Secretary of PHE Department, এই কবে হয়েছিল 2011 তে?
এটা অর্ডারটা হয়েছিল
না এই কবে হয়েছিল? Well, as far as I understand, the private respondent become assistant in 2011. Madam. That is what I understand. Madam. The communication of Joint Secretary of PH Department of 5th November 2000 set aside and is not in conformity with the provisions of the seniority rules of 81. The draft gradation list published on January 25, 2008, prepared on the basis of the communication of Joint Secretary and all the subsequent gradation lists published by the PHE Directorate are set aside. Two separate cadres are to be constituted, one for SAS mechanical, other for SAS electrical, and they cannot be indulged in a single gradation list. The promotion to the post of assistant engineer is to be done on the basis of quota to be fixed, on the basis of the cadre strength of SAEs and SAEs, mechanical and electrical, as discussed above with the rider, that the quota for one service cannot be diverted to the other service, but can be carried forward in the absence of the availability for suitable candidates for promotion. And the last is the observance of the finance department of such date are justified in the law in view of our discussions. Department will be at liberty to amend the recruitment rules. But as far as I know, Malad, because may I start from the bottom of that? But I don't think there has been any amendment of the recruitment rules. Not done. Observations of the finance department, Malad, there has been no change of finance at this moment. Because as on that date also, that person remained as an assistant engineer. Then, Malad, promotion to the post, Malad, this has not been given effect to. Because, Malad, that contemplated two different cadres of mechanical and electrical. That has not been given effect to. Then, Malad, draft gradation list published on 25th January, prepared on the basis of the communication, all the subsequent gradation lists published by the PHE Directorate are set aside. Then, Malad, communication of Joint Secretary is set aside, since it is not in conformity with the seniority rules of 81. Main pair of the applicants in OA was to direct the respondent to act on the basis of finally published gradation list of 29th March 2016. That is set aside. These have, but I don't know, Malad, how this has been given effect to. I do not know. Malad, 2 is something which note 3 of rule 4 of the seniority rules is not applicable in the instant case. That is what your lordship has held otherwise in the final relief. But this, with humility, I say, Malad, from 2019, Malad, this has not been given effect to. And why I say this, Malad, kindly sees, Malad, our opposition once, Malad. সব খুলে গেছে রে
অন্যটা দিচ্ছি এটা ছেড়ে
সরি
আমি অন্যটা দিচ্ছি এটা আমাদের পয়সা
এটা তো
এটা আমি সরে নিচ্ছি
humility, Malad, kindly sees this. Malad, the position is in 2011 this person was an assistant engineer.
Opposition to কোথায় আছে? শুধু একটা ফিক্সই আছে। Where is the opposition? কোথায় আছে?
এরকম হবে
It will be around 28 pages, Malad. এরকম
এটা নিয়ে নিন
বার করো কোথায় আছে?
আচ্ছা দেখুন
সেকেন্ড কপি কোথায়? না ওটা ওরা এখনই দিয়েছে এখানকার পেজ। এটা
দেখা তো
Yes.
But subject to correction, one more submission I want to make, Malad. The challenge was, Malad, again subject to correction, Malad, was that the petitioners are senior to the respondent number 9. But as far as I understand, challenge to his being an assistant engineer was not there. Again, subject to correction. So it was always accepted that this person was an assistant engineer. Now, Malad kindly considers the situation where Malad has got the opposition, Malad. Kindly takes page 27. In exercise of the power conferred by the provisions of Article 30 of Constitution of India, in supersession of all previous rules, subject the government is pleased to hereby make the following rules for regulation of recruitment to and conditions of services in the engineering services, mechanical engineering, electrical, and the public health engineering directorate and the department of.
This was taken into account in the writ, I believe.
Malat kindly sees part one, Malat, cadre. I don't think, whatever, Malat, may I just for my sake, Malat, kindly appreciate.
These were all argued in the writ petition. I think you argued or you.
No, I wasn't there at the writ petition.
There in the
So, Malat, may I also.
was argued two different.
জয়েন্ট
everything
কার্ডারি
was
কান
there.
বলছে যেটা যশা বলছে
No, Malat, this is, as a matter of fact, it falls in line with what your lordship had held. It's a joint cadre.
Correct.
It is for that, Malat.
rules talks about
Malat, this is for, Malat, kindly see part one, cadre. There shall be the following two services, namely, the West Bengal Senior Public Health Engineering Service, mechanical stroke electrical. Malat,
I do not know something.
no, Malat, it's a season of cough, Malat.
Anyhow, yes.
May I continue?
Yes.
Malat. The West Bengal Senior Public Health Engineering Service, mechanical electrical, consisting of the post of Chief Engineer, Superintendent Engineer, and Executive Engineer. Malat, got that at page 27, Malat. 2, rule 2, Malat.
Yes.
So, Malat, there are two services. One is the West Bengal Senior Public Health Engineering. The other is, Malat, West Bengal Public Health Engineering Services.
Where is the superintendent engineer, executive engineer?
It's a 2A1. The last entry, Malat, 2A1 and executive engineer. Your lordship got that?
Where?
Malat, if your lordship has seen this page, Malat, it should be somewhere here, Malat.
I'm looking at page 27.
Yes, Malat.
Part one I am seeing.
1 2 3 which is third line.
No, I'm looking at the recruitment rules of part two.
Part 2, yes, Malat.
Part two.
No, I'm on the.
Yeah, it talks.
Oh, Malat, you're looking. Oh, Malat, I'm sorry, Malat. I'm sorry.
talks
Yes,
about the
Yes.
engineer.
Malat.
এখানে পরিষ্কার আছে
That is the feeder post is executive engineer.
Yes, Malat.
Where is an executive engineer?
এখানে এক্সিকিউটিভ ইঞ্জিনিয়ার
Page 28.
On page 28,
27 এর লাস্ট
it starts from 27 end, I believe, Malat. No, it is superintending.
চিফ এক্সিকিউটিভ সুপারিনটেন্ডিং এইখান থেকে শুরু হবে এটা দিস ইজ দ্য এক্সিকিউটিভ এখানে একদম টপ ওখান থেকে
At the very top, Malat, executive engineer, mechanical stroke electrical, subject to provision.
Yes.
Now, Malat kindly sees qualification for direct recruitment, but it is not here, it is not direct. Then Malat sees 2. Notwithstanding anything contained in any other rules of assistant engineers.
Where you are reading?
Malat, page 28. Malat, here after desirable, Malat, 2.
Desirable.
After that, Malat, 2.
Yes.
The desire was for essentials of direct recruitment. I am on the second part. Notwithstanding anything contained in any other rules of assistant engineer shall be eligible for promotion to the rank of executive engineer after he has completed 6 years of service as assistant engineer and has passed the examinations to be conducted by the Public Service Commission. And the rest is not required for this purpose. So, the promotion requires from assistant engineer to an executive engineer 6 years service as an assistant engineer. Now, as on the date of the the date of this PSC when it was sent, my lord. Let us consider the gradation list at page 110, my lord.
No, you have shown them number
No.
1 and 2.
That's why I'm submitting, my lord.
And then
For the purpose of promotion.
the private respondent at 11.
And again, I'm submitting, my lord. For the purpose of promotion, let us look at it. For the purpose of promotion, let us look at it vis-a-vis this clause, my lord. So as on that date, my lord, the respondent number 9 had 6 years of experience. There were others also, my lord. But between these 3 persons, my lord, the respondent number 9 had experience for 6 years. My learned friend's client did not have it. Now, my lord, if your lordship's order, that is where I think our client went wrong. Your lordship's order said the promotion needs to be protected. Now, my lord, if that today, if his experience is not given effect to my lord, then that would be also, my lord, with humility I submit. I could have been at the this place. I'm at the barrel end of the petitioners. Maybe at that end I would have been at the barrel of the respondent number 9. So, my lord, I humbly submit, my lord. Your lordship is now looking into the conduct of my client, my lord.
In a contempt, that is a very important thing.
Yes, my lord, conduct, my lord. That is why I'm continuously trying to submit, my lord, that, my lord, today, 2 situations, with PSC, without PSC. Let us say without PSC, first I have pointed out, my lord, that without PSC, this is what has happened. Now, with PSC also, my lord, if I have recommended, my lord, on that day, that is of 2022 August, my lord, your lordships are of the view that there is an interim order which prevented you from doing this. My lord, the maximum I could have said, my lord, and with humility I say, my lord, the first part, my lord, there has been no change of status. No change, my lord. Yes, my lord, because I was an assistant engineer in, the respondent number 9 was an assistant engineer, my lord, in 2011. The status quo, my lord, has to be with regard to the post. So as on that date, my lord, with humility I submit, my lord, there has been no change of post. My lord, if your lordships had ordered, my lord, with humility, again I say, if your lordships had not given that first part of the main order, my lord, protecting the respondent number 9, and if I had promoted, my lord, with humility, again I say, my lord, that, yes, that would have been complete contempt. But here, my lord, I have not changed. I have not changed it. And even as on that date, my lord, let us say, my lord, this is done after your lordship's order. Could the petitioners be promoted? That is what is required to be submitted by me. Because as on that date, the petitioners did not have the 6 years of actual experience as an assistant engineer. Therefore, my lord, today my client had 2 options. One is either not to send the promotion or the recommendation of the respondent number 9 where there is a vacancy, or to send the petitioners who are not eligible. Now, my lord, I will also say this. When it is said that it requires 6 years of experience as an assistant engineer, but with humility I say, my lord, this needs to be an experience on hand. There cannot be any notional experience. Even if my learned friends' clients were given, my lord, the promotion to assistant engineer, even as in 2011, my lord, it will be a question to be considered whether he would be acceptable, eligible or not. So today, before your lordship, when there are 2 parts of the order where I'm required to give effect to the one and give effect to the other, there your lordship will kindly consider that why and what the willful part, my lord. The willful part, your lordship will kindly consider. Because my lord, if your lordship gives a simple interpretation of your lordship's order, my lord, the first part requires that the respondent number 9 gets his dues as his rights to promotions. And the second part requires that they get their seniority. Now in the gradation list, they get their seniority. But your lordship, the promotion to executive engineer, my lord, is not dependent on seniority if the other parameters are not met. No, because if your lordship is, my lord, I believe, looking at your lordship, this submission which I made, my lord, I think your lordship is not finding any favor in that, my lord. But may I try and explain again once more?
Why you inculcate this sense?
But because your lordship, my lord,
I have not uttered a,
no, my lord, that's what I thought, my lord.
I have not uttered a single word.
But yes, my lord, that's what I thought, my lord, because I thought that your lordship was, my lord, why I'm saying this, my lord, again, my lord.
It's against my genetic character because I am so interactive.
My lord, that is why I'm feeling very, my lord, unnerved, my lord. Your lordship generally, my lord, say some things so I can understand what is going on in your lordship's mind, so that I can try and reflect on that. So whatever it is, my lord, may I just say this? Why I'm saying this? The seniority part.
I have already said we have understood it.
So, my lord, if
your sum and substance is, if I now summarize,
my lord,
sum and substance is that while setting aside the order of the tribunal, this court did not disturb the promotion which is extended to the private respondent to the post of an assistant engineer. But says that the gradation list should be prepared in terms of Note 3, Rule 4. You have prepared the gradation list as per Note 3, Rule 4 and found them to be in a higher position, number 1, number 2, and the private respondent at the serial number 11. Now you say when the question of promotion from the assistant engineer to executive engineer comes, the rule says that there must be a 6 years of their spending at the post in the post of the assistant engineer. It is only the respondent number 1 who was found eligible, having fulfilled all the conditions which are there, they having not fulfilled the conditions. So, according to the rules, this promotion has taken place. So there is no violation of any of the mandate.
And the promotion was post your lordship, sir.
According to their rights, they have been already put into a gradation base.
Where they are senior.
A very high position.
1 and 2.
So, if they do not fulfill this eligibility criteria, then there is no fault on the part of the authority in promoting a candidate maybe down in the line, but having fulfilled the criteria. So that has been done. So there cannot be any contempt on you. This is what your entire argument which is there.
My lord, I don't need one clarification, my lord. The promotion had not been given effect to, as far as I understand, before your lordship's order. It was after your lordship's order. And my lord, the recommendation was done before your lordship's order. So, that's what I find.
This is what his case is.
Yes.
He is really banking upon that.
Yes. It was done post. It was done post. And why was it done post? Because of these rules. Now, my lord, the point is, I'll just try and assist your lordship. Your lordship permits me, my lord. My lord, let us, my lord, on an understanding of the order, my lord, the test, your lordships are well aware. Could the person have understood the order in such a manner? Because, my lord, with humility, I say again, my lord,
No, we are conscious. If there is an any ambiguity in the order, then the contempt will not lie or will not. Second, if the order is capable of more than one interpretation, and if one is adopted by an authority, even if the court feels that the second one is more reasonable, more apt, then also cannot be punished under the contempt of court.
But I'm absolutely, I'm only on the point of willful.
Thirdly, you say that there may be an act of contempt, but if it is not willful or deliberate, the willful and deliberate comes where? It is on these two parameters or principles. If it is an ambiguous or capable of more than one meaning, then willful and deliberate will not come. If there is a certainty
Of the direction,
of the direction and not capable of any second opinion on this or interpretation, then you can't take a plea that it is not willful and deliberate because it's an act, I have to do it.
Absolutely. If it's a direct order.
So this is what let us find out that was it so ambiguous? Was it so
I did not say
capable of
ambiguous.
more than one interpretation?
But I am.
The authorities have interpreted in this way, knowing fully well the language, the English language, the words, all the jargon of the expressions of the language.
May I just, for once, Malad?
What do you think? We have given you an opportunity. You asked for 10 minutes time. We have given you more than that.
Lordship can give
How
me
many
2 minutes.
10 minutes have already gone?
2 more minutes, Malad. 2 more minutes. I can, Malad, I am requesting a Lordship. Malad, on the ambiguity, I never said ambiguous, Malad. I never submitted it's an ambiguous order. What I said was, Malad, there were two parts to the order. Both were to be given effect to. Gradation list was to be prepared in respect of seniority. That has been done. And this person, the promotion shall not be disturbed. So when a promotion has been not set aside, then his eligibility under the rules which I had showed your Lordship, Malad, was thought not to have been disturbed by your Lordships. That is the direction. And today, Malad, let us take the reverse part of it, Malad. With humility, Malad kindly appreciates that I don't give the respondent number 9, Malad, the experience part of it. Malad, would I or would I not be acting contrary to your Lordship's order or not? That is also a question which needs to be answered. Because according to the order, Malad, your Lordships have not disturbed him. His promotion is there from 2011. That was not under challenge before the tribunal.
Language is not an experience. The experience is only in respect of a direct recruitment.
No, Malad. No, Malad, with humility. No, Malad, kindly, Malad. Malad, if that is the case, Malad, then I think I can. And kindly cease, Malad.
Read that.
Notwithstanding anything contained in any other rules, assistant engineers shall be eligible for promotion to the rank of executive engineer after he has completed 6 years of service as assistant.
Experience.
Sorry, Malad?
Where is the question of experience? Experience is a relative term.
Malad, it's more than that.
No.
This says 6 years of service.
I'm telling you.
Malad. And I will try and assist that with another judgment, Malad.
That's why I say in direct you will find experience. In direct 6 years experience.
So,